Hello, welcome to the Law Professor channel. In today's presentation, we shall be looking at master-servant relationship in vicarious liability. And our learning outcomes for today are threefold. We would be able to define or appreciate what is meant by a master-servant relationship. We should be able, at the end of the presentation, also to know the various tests that have been funded by the courts in order to determine what is a master-servant relationship and laying emphasis on the defects or the challenges of each of those states. At the end of the day, we should also be able to apply the principles of vicarious liability where a master-servant relationship exists. So, in order to assist us in attaining these objectives, we will recall that we had said that vicarious liability arises in tort where someone is held responsible for the tort of another person, and this tort is usually committed in the course of employment. We also said that for this to arise, it must be found that they are in a master-servant relationship. So this master-servant relationship, how has it been defined? How do we know when someone is in a master-servant relationship? Now, over the years, the courts have tried to explain what this relationship is, and they have developed some tests to assist them. These tests were developed not simultaneously, but gradually, one after the other, because when one is developed and society progresses, then they realize that the test is not really useful, it's not exhaustive, and so they develop another test. Now, the test try to distinguish a master-servant relationship from a relationship between a master and what is called an independent contractor. A master and an independent contractor. Usually, for vicarious liability, the master is responsible for the tort of the servant, but this, as a general rule, but he is not responsible for the tort of the independent contractor. The general rule is that the master is not responsible for the tort of the independent contractor. There are some exceptions to the general rule about independent contractors that we'll be looking at in subsequent presentations. Now, so that is the general rule. Vicarious liability will exist when there is a master-servant relationship, but it will generally not exist where there is a relationship between the master and an independent contractor. So, what are the tests that have been developed to distinguish the master-servant relationship? We will be looking at four of them in this presentation. You have the control test, you have the contractual terms test, you have the organizational test, and you have the multiple test or the combined test. The contract terms test states that in order to determine a master-servant relationship, you must look at the contract term, the agreement that is signed between the parties. How did they describe themselves? So if they describe themselves as being in a master-servant relationship, then they should be construed as such. Okay. But of course, you at in modern times, you're not going to see a contract that will say we are in a master-servant relationship. You have to look at the agreement comprehensively and determine whether you can really say this is a master-servant relationship. Now, in this context, you must note one thing, that a master-servant relationship is usually described as a contract of service, while a master independent contractual relationship is usually described as a contract for services. In a contract of service, it is said that the relationship is one of control, and that was what actually gave birth to the control test that we are looking at next. But staying on the contractual terms test, when you are looking at the contract terms, you are not going to see them describing themselves as in a master-servant relationship, but you are trying to see where the interaction lies, where the power play lies, and how can we look at the entire document so that even if they describe themselves as being in a master-servant relationship, if you look at the entire document and it doesn't seem that they are in a master-servant relationship, then they will be held to be in a master-servant relationship. And the difficulty of contractual terms test lies also in the fact that it is not fixed. It is not with each contract, you have to define what is the relationship. So there is no precedent that you can get from that relationship. So the contractual terms test actually has that limitation that you have to begin to look behind the veil and find out how do they really consume themselves, what are their intentions and what are they. And that was what eventually led to the control test. Now, the control test gives us some room to give some examples. In control test, it says that you look at where is the power play, who has control over what. Now, let's look at some relationships that are common in the society. And I will use the relationship of a driver and the employer as an example, because a lot of cases in vicarious liability arise because of negligence, road driving, accidents, and then the driver is being held primarily liable and you are trying to sue the employer of labor. When you have a driver, for instance, a personal driver, who you are paying salary at the end of every month, when you are going to use your driver, the control test says that in the master servant relationship, the employer controls not only what the employee does, but also how he does it. How does he do his work? The employer can determine it. So when you have a personal driver, you determine when he resumes in your house or in your office, anywhere you want him to resume. Some of them will even stay with you. At any time of the day, you call the driver and tell him where you are going. When you are taking it, assuming you want to get to Lekki, you might tell him, I want you to take Third Mainland Bridge. Or you might say, no, I want you to take Echo Bridge. The driver has no choice. He doesn't even own the vehicle. He's come to render his service unto you. But you control everything. You can determine when he goes for lunch. You can determine how he drives. You can say he cannot speed beyond this limit. You control not only what he does, you also control how he does the work. Now, you compare that kind of a driver with when you take a ride, like you take an Uber ride. You enter that vehicle, you do not control when the man decides whether he wants to do work that day or not. But you can decide to switch off. Between the passenger and the Uber driver, all you know is that you have ordered the ride and you get to the ride, and you can decide to take some routes. Although in these days, it may not even be a perfect example of contract for services. But to a reasonable extent, you can actually tell the driver, I don't want you to take that route. Ordinarily, that driver might decide to take the ride or not take the ride. He might decide to say, I'm not working today. Even with the Uber company that he's working for, because it's the new kind of relationship in society today, he might decide the days he's going to put his app on and it's not going to work. I might decide that it will work today. In that case, they cannot control how he does the work, even though he's working for the organization. But you have limited control on how he does the work. In the days where we didn't have Uber or Bolt, all those rights, when you call a taxi, you just call to taxi, I'm going to Lekki, I'm going to Banana Island. That's all you can control, that it gets you there. He might try to take a route that is not, you don't know, all because he wants to avoid the traffic. So what are we saying? In the two examples of your personal driver in your house who is using your car to take it out, you control everything about that ride. In the other two examples I've given, you cannot really play much control on them. In fact, assuming you're on that trip and it has an accident, you can finally get out of that ride, end the trip, and take another ride and walk away. But if it was your personal driver, you are not going to be able to do that. So the personal driver that you have employed, giving salaries every month, is regarded as being in a contract of service. While the other example of the Uber driver or the ordinary taxi is regarded as a contract for services, like an independent contractor. You could also use the example of where you call a mechanic to repair your car, a plumber to fix something in your house, an electrician. These people come into your home or into your space and they render services unto you, and you pay them and they go away. The next time you don't have to call the same person. But when you had a company and you had employed an electrician to be working, for instance, let's take a university environment, and you have plumbers are employed, they are being paid salaries, they stay in the university system all throughout the day. You have electricians, you have drivers as well who drive some members of staff. But these people, even though they are having the same title of driver, electrician, plumber, they are in a contract of service. They are in a master servant relationship because the university will control when they report at work, when they close. The university owns the properties that they are driving, they are using, the equipment, maybe the vehicle for the driver, for instance. So in this context, they are in the contract of service. So it's not necessarily the title of your career that determines whether you're in a contract of service or services, but rather the content of the employment. The content of the employment. So the control test was useful at a point in the history of work relations, but as society advanced, it was realized that it is not all the cases that someone controls the terms of your that someone who is you are unable to control their terms of employment will be in a contract for services. One of the ways that this was discovered to be a problem was with employment that had to do with professionals. For instance, medical personnel, doctors, and professionals working in offices. As a professional, you have the rights of judgment about what you want to do about your employment. Yes, you're employed, maybe you're employed in a hospital as a consultant, for instance, medical doctor, nurses, and whatever. The hospital does not control how a doctor does the work. The judgment, the professional judgment that he exercises, if he says I want to perform a surgery on this patient, the management will not say this is not how you don't perform a surgery, this is what you should do. These people, therefore, are not under that kind of control that the driver that we have talked about earlier is under. Yet, these professionals are regarded as in a master-servant relationship because they are fixed terms of coming to work. They don't work elsewhere. They are paid salaries at the end of the month. They are still regarded as being in a contract of service, that is in a master-servant relationship. So that was the difference with the control test. It could not meet the requirements of all kinds of relationships. And so another test was developed over the years, and you can see the case of Ferguson and Dawson in this respect. The third test that we're looking at is the organizational test. The test is an attempt to correct the defect of the control test by saying that even where control is not effective with respect to a relationship, for instance, the example of the medical personnel that I've talked about, as long as you can say that the work of the employee is embedded in the organization, it's part of the organizational structure, then that person is in a master-servant relationship. For instance, the doctors that I talked about, maybe engineers in a company, as long as they are working as part of that company and they are an intrinsic part of that company, they will be regarded as employee, even though the company are in a master-servant relationship, even though the employer does not control how they do their work. And you can see the case of Stevenson, Jordan, and Harrison Limited against McDonald and Evans Limited. Okay, so the employee's work is done as an integral part of the organization. The defect also in this test is that a lot of professional services are not integrated into the organization. In fact, in today's world, where people now work from home, where people do not, usually, in fact, you have employees that never see their employer, this kind of a test will run into a problem because their work in terms of the substance may be embedded in the organization, but there is no measure of interpersonal relationship between the employer and the employee. So these tests are evolving, so and that's what you must take note of. Then you have what is called the combined test, which says that you should combine all the tests that we have been looking at: the control test, the party discretion, the organization test. You should combine them, and then when you combine them, try to find out what exactly is the relationship. And in combining them, you can look at things like whether wages or salaries are paid, or whether the person is just giving. It just gives a bill and you pay once and for all and move away. Whether there's a definite or indefinite term of employment, is it a contract for 2 years, for instance? or give the person a letter of employment that is long-standing. For instance, you have civil servants, their terms of employment is indefinite, okay, as against a contractor who comes to do a service, maybe to construct a building or construct a reservoir, and after it's finished, pay once and for all, and he moves on. That would be an independent contractor, and the person moves on. Whether they have a fixed place of work and time of work. Now you see that we have a challenge now in the modern age where we have a lot of working from home being done. So there's no fixed place of work in that context. And so if you are going to use that test, you say those someone that is working from home is not in the contract of service. But then you still have to look at other factors. So in the combined test, therefore, it talks about looking at so many issues, whether whose equipment is being used. Is it the employer's or the employee's own? If it's the employee's own, there's a high probability that it's not a master servant relationship, but it's an independent contractor. Whether there's an opportunity for the worker to make profits from the employment. So these are the tests that are being used to determine master servant relationship as against independent contractor. And some people have been held now and judicially noted to be in the master servant relationship, like domestic staff, like factory workers and clerical staff, while independent contractors will be like a freelance journalist, so photographers and lawyers in private practice and what have you. At the end of the day, we could say that each relationship must be construed in the light of its own facts in order to determine whether the parties are in a master servant relationship or in an independent contractor relationship. The whole essence of these tests is to determine whether there should be vicarious liability. So at the next presentation, we'll be looking at other aspects of this relation.